Welcome back to class. Today we'll be talking about employment and labor law. And as we look into that, we'll be able to look at the fundamental legal principles governing employment relationship and also ensuring workers' protection and business stability. We'll also look into employment contracts, the type of arrangements, the rights and obligations with comparative insights into global labor regulations. This we will surely look into. And by definition, um, or before I define what labor law is, employment and labor law are interconnected yet distinct. So they are different, though they have connections. They are different in terms of what they do, and we see that in the definition that will be given now for employment law. It actually focuses on individual relationships covering hiring, um, contract, wages, hours, safety, and anti-discrimination. It's actually focused on this that has been listed, and it aims for a balanced, lawful relationship between the employer and the employee. And I want you to note those two concepts, the employer and the employee, because they are actually going to be involved in discussion. We will involve these two concepts in our discussions. And for labor law, it actually deals with collective work dynamics, such as the trade union and collective bargaining, the which governs this governs negotiation on wages, conditions, and dispute resolution, crucial in sectors with strong worker organization. When we talk about, in the definition I gave the previous time, I talked about employment law dealing with having a balanced lawful relationship between employer and employee. We need to talk in now what is actually the relationship between employer and the employee. So there is actually a legal classification of a worker as an employee, and this has significant consequences, entitling them to statutory rights like minimum wage protection from unfair dismissal and leave. And incorrect classification can lead to legal disputes and penalties on both ends. So when we now talk about the relationship, we could see that the employer has control or authority over the task that is to be done, the time to do it, the location where it will be done, and the resources that will be used to do it. And this is very, very important. If there is actually a work to do, there should possibly be everything prepared for such an employee to work on for better um, um, fulfillment of task or responsibility. And we see the mutuality of obligation, whereby the employer provides work and an employee accepts and performs as instructed. And it is not only worth for an employer to just provide work alone. There should be an employee who accepts it and do what he or she is assigned to do. And that is why there is mutuality in obligation. Also, there is an integration into business where employees' role are essential to core function integrated into the operation. So the employee has a role which is essential to core function, and this is what is integrated into the business operation. Um, and this is important too. And this states the legal relationship between the employer and the employee. There are responsibilities that each of these parties need to actually carry out. And the crucial principle is vicarious liability, where an employer can be held responsible for an employee's action during employment, emphasizing the need for proper hiring and training. And that is why we need to look into the responsibilities of employee. And first, it is that he or she should diligently perform assigned duties to the duties that has been assigned to him. He or she should be performed diligently. Also, there is need for an employee to comply with complaints policy and safety protocols. Also, he has the responsibility to maintain confidentiality and loyalty to the organization. This is very core principle when we talk about professionalism. And also, he needs to avoid um, misconduct. An employer needs to avoid misconduct. And on the part of the employer, um, on the part of the employer, he has the responsibility of providing a safe and inclusive workplace. It's not only a, a thing, it's actually a thing for an employer to provide a work. It's another thing for him to actually provide a healthy, safe, and inclusive place where the employee would find expression. So it is very important for the employer to provide such a place for a healthy work and relationship between them. Also, an employer must pay wages and benefits as per obligations. Three, the employer has the responsibility of complying with employment standard. And lastly, an employer ensures fair termination procedure, not that we just terminate the procedure anyhow, just saying because I don't want you today and you can just go tomorrow. No, there are laws that guides it, and he is responsible to ensuring fair termination procedure between him and the employee. So it is very important that we look into it, and we can still go further to read from the notes. And we will now move to employment contracts and the types, employment contract and the types that we have. An employment contract is a legal enforceable agreement outlining rights, responsibilities, and expectations. A written agreement is best practice for clarity and dispute prevention. And so this is actually an enforceable agreement, and it's actually a written agreement, not just that it is just what you agree about. We talked about the types of contracts before when we mentioned whole rights. Beyond whole rights, a written agreement, and it's for best practice, for clarity, and for dispute prevention. We have types of employment contracts, and these are the permanent or indefinite contract, which means that there is no predetermined end date. Highest job, and it ensures highest job security. Also, we have a fixed term contract, which has a time bound for specific date or project completion. We have a casual or 0 hour contract, which is highly flexible, no guaranteed minimum hours. You just do and then you go. And then you have the part-time contract, which is fewer hours than full-time, and they have pro rata rights. We have a temporary or agency contract where workers contracted by agency for client business. Uh, and we have the apprenticeship or training contract, which is focused on skill acquisition and vocational training. We are talking about the fact that the employer would have the responsibility of following due procedure in terminating um, employment for an employee. And it is very important that we look into it. And for the termination of employment and dismissal law, for termination of employment, it actually refers to the formal end of an employee's working relationship with an employer, and this can be voluntary or involuntary. So you need to note that it is a formal end. So if it is not going through the necessary agreement or law, it is not formal. And so termination of employment refers to a formal end of an employee's working relationship. And by this, it can be voluntary and involuntary. So I can decide, or such an employee may decide to retire voluntarily, to terminate the employment voluntarily and also involuntarily on both ends. And termination law varies across the jurisdiction that we've been looking at. For UK, it requires fair procedure after 2 years. For US, it is actually at will but protected by anti-discrimination law, and the EU has strong protection. For Nigeria, the law recognizes wrongful termination, particularly if the contract terms or statutory guidelines are violated. And for dismissal procedure and fairness, the dismissal procedure and fairness, the dismissal as a specific form of termination typically arise from the employer's decision to end the contract due to the employee's conduct, performance, or redundancy. So it is based on the conduct, the performance, or redundancy of such an employee. So on that basis, there can be a form of dismissal. And legal system requires fair procedure, such as warning, hearing, and notice period. Failure to follow this can lead to unfair dismissal claim, and employees are protected by statutory and contractual rights, including minimum notice, severance pay, and anti-discrimination law. Workers also have their rights, and the discrimination harassment also. Um, Anti-discrimination law protects against unfair treatment based on race, gender, disability, age, and more. And then for harassment law, it addresses unwelcome behavior with employers' responsibility for policy, investigation, and training. And below are also the core rights of employees. And the first is a fair wage and equal pay, which is a minimum compensation and equal pay for equal work. It is not that you just think that you are just doing me good and you just give me a certain amount. No, there should be an equal pay for the work that is being done. So it should be a fair wage and minimum compensation. It must meet a minimum compensation. And also, there is safe working condition. An employee is open to safe working condition whereby the workplace should be free of hazard with preventive measures. There should be preventive measures that are being put in place. Also, there is reasonable working hours and rest, and there should be a regulated hour break and paid leave. So we have some organizations that you just continue to work. You can start working from 8 and you continue to move on until you are able to work up till evening. No, there should be a regulated hour and there should be break, and for leave there should be a payment that is being given. Also for trade union, they have right as per that, and that's right to form or join union and collective bargain. Also, workers have rights to protection against unjust dismissal, and this is safeguard against arbitrary or wrongful termination. We have the global labor law framework, and for that, it's very globally, but share core principles. And for the United Arab Emirates, there is a strict labor code, but no trade union. For the United Kingdom, it offers comprehensive protection and strong union rights. And that of Canada law vary by province, but uphold human rights. And for Australia, there is Fair Work Act sets national standard, and Nigerian law are less enforced, especially in the informal sector. So the EU harmonizes standard across member states, and lastly, the US follows at will employment with federal anti-discrimination law. In conclusion, employment and labor law is a fundamental aspect of business and company law, and ensuring a fair and regulated relationship between the employer and employee is very, very important. So it is better to understand, there is need to have an understanding about this framework, and for business to maintain compliance uphold ethical employment practice and also mitigate legal risk. Thank you.